Today, I'll examine antitrust law and its role in protecting competition in the marketplace. We'll look at why these rules exist, the core principles that guide them, and the remedies available when competition is threatened. The broader goal is to understand how businesses can operate successfully while staying within legal boundaries. Competition is not simply a market outcome. It is something the law actively works to preserve. This foundation will help frame the business environments and concepts explored throughout the presentation. Antitrust law is a framework that promotes fair competition and limits monopolistic behavior in the marketplace. Its central idea is simple. When competition remains open and meaningful, consumers and businesses generally benefit, and the broader economy is stronger. The term antitrust comes from efforts in the 19th century to break up powerful business trusts or conglomerates that controlled entire industries. So, antitrust law is not about punishing success. It is about preventing companies from using excessive market power to eliminate competition and restrict consumer choice. U.S. antitrust law rests on three complementary pillars. The Sherman Act of 1890 provides a broad foundation, prohibiting agreements that restrain trade and making monopolization or attempted monopolization illegal. The Clayton Act of 1914 focuses on specific practices, including certain mergers, price discrimination, and exclusive dealing, when they may reduce competition or create monopoly. Also passed in 1914, the FTC Act established the Federal Trade Commission and prohibits unfair methods of competition, along with deceptive acts or practices in commerce. Together, these laws protect competitive markets from different angles. Antitrust law serves four connected purposes. First, it protects consumers by preventing monopolistic behavior that can lead to higher prices, less production, and lower quality products. Second, it preserves market fairness, giving small businesses a genuine chance to compete on merit rather than being pushed out through predatory or exclusionary conduct. Third, it spurs innovation, because competition encourages companies to improve quality and create new products. Finally, it safeguards democracy by limiting excessive economic concentration and the political and social influence that can come with it. Antitrust violations are evaluated under two main legal standards, and the distinction is important. The per se rule applies to conduct considered inherently harmful to competition, such as price-fixing cartels. When this standard applies, the behavior is automatically illegal, and businesses cannot defend it by offering possible justifications. The rule of reason takes a more nuanced, case-by-case approach. Courts weigh the conduct's pro-competitive benefits against its anti-competitive harms before deciding whether it violates antitrust law. Together, these standards help determine how rigorously a particular business practice is evaluated. This slide focuses on monopolization, a central concern in antitrust law. A monopoly exists when one firm has enough market power to exclude competitors and charge prices above competitive levels. But having monopoly power is not automatically illegal. The legal concern is the willful acquisition or maintenance of that power through anti-competitive conduct. Examples include predatory pricing to drive out rivals, exclusive contracts that block competition, tying unwanted product together, or refusing to deal with competitors without a legitimate justification. The key question is how the market power was obtained or maintained. Antitrust enforcement is shared among several public and private actors. The Department of Justice, or DOJ, can bring both civil and criminal cases, including cartel prosecutions and reviews of major mergers. The Federal Trade Commission handles civil antitrust matters, merger reviews, and deceptive trade practice investigations. State attorneys general may sue under federal or state law, often working together in multi-state actions. Finally, private plaintiffs who are injured by antitrust violations can sue directly for treble damages, meaning 3 times their actual losses, plus attorney's fees under federal law. This slide outlines the government's main antitrust remedies, ranging from punishment to structural change. Criminal penalties can be severe. Corporations may face fines up to $100 million, while individuals can face up to 10 years in prison and $1 million fines for per se violations. Civil injunctions require companies to stop specific anti-competitive practices. Structural remedies go further, potentially requiring divestiture of assets or divisions to restore competition. Finally, treble damages allow private plaintiffs who prove harm to recover 3 times their actual losses, creating a strong deterrent. These 4 cases show how U.S. antitrust enforcement has evolved over time. In 1911, the Supreme Court broke Standard Oil into 34 companies, establishing a defining structural remedy. In 1982, the AT&T breakup transformed telecommunications by creating the regional Baby Bells. In 2001, Microsoft was found to have illegally maintained its operating system monopoly, but the settlement focused on behavioral restrictions rather than a breakup. Most recently, in 2024, a federal court found Google illegally monopolized search, with remedies still underway and potentially including divestiture. The Hart-Scott-Rodino Act requires companies involved in large mergers to notify regulators before the transaction closes. This creates an opportunity to identify competitive concerns before they occur. Regulators typically focus on 3 questions. First, how concentrated will the market become? Often measured using the Herfindahl-Hirschman Index, or HHI. Second, could a combined company raise prices, reduce output, or eliminate an important competitive threat? Finally, regulators weigh entry barriers and efficiencies, whether new competitors can enter easily, and whether the merger's benefits outweigh potential harm to competition. Antitrust law protects competition, not competitors, with the goal of benefiting consumers, encouraging innovation, and promoting economic fairness. The Sherman, Clayton, and FTC Acts provide the legal foundation. Violations include price fixing, monopolization, and anti-competitive mergers, with remedies ranging from fines to breakups and treble damages. Compliance supports sustainable growth.